and the writers.
My Lord, I thought it might be helpful if I were to summarise the position where I believe we have reached and the destination which I hope we are travelling towards. And we prepared for that purpose 10 propositions which my learned friends have had receipt of, and if they could be handed to my lords now.
Yes. Thank you.
Yep. Thank you. My Lord, since this is, of course, a public hearing and we have a principle of open justice, maybe I'm forgiven for reading these out shortly before developing them. First, in terms of the dividing line between criminal and civil proceedings drawn by Lord Devlin in Colony for the purpose of the application of the Latin maxim now embodied in the common law Nebo David bis vexare in causa unit, should continue to read, disciplinary proceedings fall on the civil side of the line. 2, it follows that where the cause of action in the sex of proceedings is the same, the relevant legal principle is res judicata, not aut quit. See our printed case, paragraphs 3 to 58, for substantial reference to principle and authority. 3, the solitary dissent is in Harry Lee Wee, where the point was unargued, is obiter, and it's incorrect. See our printed case, paragraphs 55 to 57, and the Court of Appeal's judgment in this matter at paragraphs 21 to 22. 4, for the purpose of res judicata, the causes of action, or in the context of discipline, the charges, must be the same. See Spencer-Bauer, paragraphs 102, and then materially 702, 601 deals with another point.
Mr. Buff, can I just ask you a question? Do you accept that res judicata, cause of action estoppel, issue estoppel apply to this type of disciplinary tribunal?
I do, but I'm going to suggest there is a modification.
Now, why do they apply?
Why do they
It's
apply?
not a court, is it?
No, it's not a court. I mean, there is authority for the proposition. I think Mr. Justice Lightman in one of the cases said that the finding of the pensions ombudsman could itself create a res judicata for the purpose of some subsequent hearing.
Again, statutory tribunals are in a different category. Is that case with a Greek name, Thrasivulu?
Thrasivulu, yes.
But that's statutory tribunals.
Yes.
Now, here, just assume there's been a finding by a disciplinary tribunal of fact, and the professional wishes to reopen it in a later hearing. Now, in fact, these rules prevent that. The accountancy rules prevent that happening because they make an earlier finding conclusive in later proceedings. But if they didn't, would there be an issue estoppel? Because it's not a court of competent jurisdiction.
No, the concepts of court of competent jurisdiction were brought into play when analogies were sought to be drawn, but unsuccessfully, with criminal proceedings. In this instance, it's, as I would understand it, but I'm not, as it were, going to reject a contrary proposition. The argument would be that there's a fundamental principle that someone ought not to be troubled twice by the same
by
matter.
analogy, it's not because it's a court.
No, it is. Oh no, it's certainly by analogy. No, it certainly is not a court. For a variety of reasons.
And similarly, abuse of process was assumed by Lord Wolfe in that case, unreported case about solicitors, to apply to the solicitor's disciplinary tribunal.
Yes.
But again, that's by analogy because it's not a process in the technical sense.
No, it has to be by analogy. Of course, it's not only Lord Wolfe, but for that purpose, the Privy Council and Harry Lee Wee again applied the doctrine of abuse of process. And again, it is by analogy. I mean, it's derivative of principles that have been applied in courts of law, but derivative on the basis of what is regarded to be a fundamental principle of justice. But that's the way in which I understand it's put.
Does Article 6 apply?
Yes.
Yeah, Article 6 certainly applies, though instructively, that this is no longer in issue. The particular provisions of Article 6 pertinent to criminal proceedings, what I call the add-on procedural rights, have been held in a series of cases not to apply. One involved Mr. Stern, I remember the other is a case called Fluorose about the Financial Services Authority.
Yeah.
And I think that's well-established jurisprudence that although, as your lordships well know, there's an autonomous concept of criminal case in the Strasbourg jurisprudence, nonetheless these disciplinary matters have been held to fall outside it.
Well, for 30 years, the Strasbourg has decided that
Yes,
Article
I'm not
Yes.
suggesting. I mean, certainly that it applies,
Yes.
but it applies. The fundamental principles
Yes.
apply: independent, impartial tribunal, etc. But the specific criminal procedural add-ons do not apply.
So when it comes to such matters as, quote, on the merits,
Yes.
one isn't bound by the cases in the field of issue estoppel or cause of action estoppel in relation to court proceedings.
No.
We're applying it by analogy.
It
so
has
it
to be
might
applied
be more
by analogy,
might be
and
more flexible.
maybe more flexible for that reason. I am going to, as your lordship will see in a moment, pick up something that my lord the President suggested in argument, the possibility that there may be some form of exception to the strict application of res judicata in proceedings of this nature which have the public interest I mentioned. And I'll come to that if I may. It's one of the propositions that I was about to address. But to my Lord Collins, the answer is it has to be by analogy.
When you say it's by analogy, do you mean what you're really saying, as I understand, that there is a fundamental principle
Yes.
in the law,
Yes.
and that it applies to courts,
Yes.
but it also applies
Yes.
in proceedings like this. Whether one says it's by
No,
analogy
I
or
think
not,
by analogy is perhaps not the happiest phrase. One has the fundamental principle, and one has a series of, as it were, situations in which it's
yes, exactly,
applied.
to which it applies.
Yes, yes. But I can answer saying it isn't, of course, a court of law, and therefore doesn't apply, as it were, directly as if it were a court of law.
It's very like a court of law.
Well, yes, like is not the same as.
Indeed, I don't myself quite understand why it isn't a court of law. Why isn't it a court of law? It has powers to fine, it has all sorts of powers.
Well, my lord, I mean...
It might be part of the ordinary court structure, but I don't know what...
Well, my lord, there is...
Depends for
copious-
what purpose one's asking the
Which is
question.
true. For example, questions of contempt of court have arisen. There have been cases in the House of Lords about that. I confess I was not prepared to come to argue this. I'd assumed it was axiomatic that there was a distinction between a court of law and a tribunal of this kind.
Well, obviously there are some distinctions.
Yes.
But,
Well, the question is whether, of course, your lordship will feel that the distinctions are material to the issues that you have to decide in this particular appeal.
depends how fundamental the principle, I suppose, that my Lord Roger refers to.
Yes. Now, I think I wrote Proposition 4 or Proposition 3 when Lord Collins asked me the question.
Sorry.
Yeah, I think I can repeat Proposition 4 as
I
is
think
repetition.
four,
For the purpose of race, yes, it is. The causes of action or in the context of discipline, the charge must be the same. That's what provoked my Lord's question. See Spencer Barn, it should be paragraphs 102 and 702. 5. In this case, the charges were in fact different. See the particulars of the discreditable conduct charge, reflecting a distinction drawn in the disciplinary bylaws themselves, one based on the fact of conviction, the other based on the conduct which led to it. 6. If per contra, the charges are to be construed as both charges based on the conduct, then there has been in the first tribunal no decision on the merits, another sine qua non of the application of res judicata principles, and here your lordships might simply pen in Spencer Bauer 1.02 and 6.01, because there was no decision that he, that's Mr. Coke-Wallis, had or indeed had not deliberately breached the Jersey direction. 7. In any event, given the disciplinary context, the Supreme Court should recognise a public interest exception to the strict application of the doctrine, which will be absent when there is conventional civil litigation between two parties. 8. As to abuse of process, it is accepted that the concept applies in the civil, including disciplinary sphere, as well as in criminal proceedings. See, for example, Harry Wee and in Wee the matter of a solicitor, Lord Wolfe's decision. 9. The fact that the second set of proceedings could and should have been brought at the same time as the first set is a necessary but not a sufficient basis for finding abuse. The true question is whether it is abusive to bring the second set of proceedings. The decision on whether there is abuse or not depends upon an evaluation of all the facts, the merits of the second set of proceedings apart, and all the private and public interests involved. 10. There is no basis for a finding of abuse in this matter. There has been no harassment of Mr. Coke-Wallis by the Institute, and there is a supervening public interest in ensuring that if he is indeed guilty of the conduct charged in the second conduct charge, he should be prevented from further practising as a chartered accountant. Now, my Lords, I've reached proposition 5, and if I may, I would like to return briefly to it, because in our respectful submission, and bearing in mind particularly the way in which the court has so far provisionally approached it, it appears to us to be critical to the outcome of this particular appeal. So can I ask your Lordships just to go back to the bylaws that you have in the core volume at tab 7, out another sub-tab of the general tab 6, and it's at page 49 and 51, and remind your Lordships as to what our submission is in relation to, in particular, 7.1 at page 51. If I may put it in this way, ask oneself the question, what under Article 7.1 is conclusive evidence of the Commission by a member of an act that's a discreditable act under 4.1a? That's the question that is posed, and the answer in our respectful submission is provided by 7.1 itself. The answer is the fact that a member has been found guilty of an offence which satisfies 3 criteria. 1, it must be an indictable offence. Secondly, that must be a finding by a court of competent jurisdiction. And thirdly, it must be 1, an offence which corresponds to 1 indictable in the courts of England and Wales. And in our submission, no more is then needed for exposure of the member to disciplinary action under 4.1. It's not even necessary for us to contend, as I have sought to contend, that being convicted in ordinary parlance is a discreditable act, or even to draw analogy with those several cases to which reference has been made in the areas of the solicitors, pharmacists and police officers, cases 16, 14 and 42 in your Lordship's bundle, in which the fact of conviction is itself grounds for disciplinary action. I put it more broadly with respect. In our respectful submission, this particular bylaw has its own vocabulary and its own definition, and to put it in a single sentence, the fact equals the act. That's how it is structured. And in our respectful submission, those who drafted it were perfectly entitled to make provision in that form.
Well, the fact of conviction is conclusive evidence of the commission of the act.
Yes.
And that's what it actually says.
That's what it actually says.
And what, after all, you are trying to prove is, in order that someone should be liable, is that he or she has committed an act or default, like to bring discredit on himself. And what 7 then does is tells us various different ways in which various things can be proved. And the first one is the one, but it's all to do with, as it's headed up, proof, isn't it?
Yes.
Yes.
But
it's methods of proof.
It's a proof, but proof of what?
Proof
the proof
of,
is a commission by an act of him as such an act or default as is mentioned. But what is that? It's the fact that he's been convicted, etc.
No, it's the proof. It's the proof that he did something which was discreditable.
Yes, but with respect, it's not in a vacuum. I mean, it obviously, one can't, as it were, decontextualise it. Is there? What's the starting point? That he has been found guilty, etc., etc.
But Mr. Beloff, you seem to be putting it into a vacuum and departing from reality. You accepted, I think, yesterday, that if this had been a true bill as drafted, there had been an indictable offence in England and Wales that matched the offence in Jersey, and the charge had been found made out, and he had then had sanctions imposed for that offence, it would be an abuse to then bring proceedings against him for the underlying facts and impose a second penalty. Did you not?
Well, what I said was that if he had already been found guilty of a discreditable act, there'd be no purpose in, as it were, bringing proceedings again in relation to something in which the underlying nexus of facts was similar. What would the purpose be? You certainly abuse it.
You look at the underlying nexus to decide whether it would be an abuse to bring a second set of proceedings.
Yes.
Well, why don't you look at the underlying nexus here to see whether it would be an abuse to bring a second set of proceedings?
I'm, at the moment, with respect, my Lord, I'm dealing with the concept of res judicata. When I come to abuse, then I've got, as it were, on any view, stronger weaponry available.
I see. So your answer is it would not be res judicata to have brought
this is all I'm dealing with at the moment.
Okay.
My Lord, if one then goes, can I just remind you what would then happen? Your Lordships haven't been asked to look at this to date. If you go to 59, you see what the powers of a tribunal are. This is at bylaw 22. If the tribunal, sub 1, if the tribunal appointed to hear a formal complaint is of the opinion that the complaint has been proved in whole or in part, it shall make a finding to that effect. Omit the remainder. 2, if the tribunal finds the formal complaint has been proved or whole in part, it may, unless it is of the opinion that in all the circumstances it is inappropriate to do so, make against the defendant one or more such of the orders available against him under the following provisions of these bylaws, and then one looks down to see what they are, and they include, at 3, as one can see, in a hierarchy of sanction, A being the most severe and H being no doubt the least severe, A being exclusion from membership, H being fine in specified sum, and one can see the intervening, not unfamiliar sanctions of that kind. And then 4 and 5, of course, aren't concerned with these. So that's what then that's what happens when there is a finding of discreditable conduct. Now I focused on 7.1. I go back to 7.3. If there is a conviction, then the only criterion that 7.3 imposes is that the conviction be before a court of competent jurisdiction. It can be in the United Kingdom, it can be elsewhere. The offence doesn't have to be indictable.
Sorry, is it 7.1 is it you're at?
I'm so sorry?
7.1. Is it 7.1 you're at?
No, I'm 7.3, my Lord. I'm at 7.3. I'm sorry, I passed 7.1 to draw the contrast.
Yes, sorry.
7 sub 3 at page 51. So just to repeat that in relation to that, where there have been criminal proceedings before a court of competent jurisdiction, and it matters not whether the offence was indictable, it matters not whether there was a corresponding offence in the law of England and Wales, if the conviction was by an overseas court, which of course it may not be, then the findings of the court which convicted, but not, one notes, the conviction itself, may be prima facie evidence of facts which will need to be classified, of course, as sustaining a conclusion of discreditable conduct under 4.1 if the charges succeed, and of course there may be other evidence relied upon to buttress the findings of the court. And then, of course, as I mentioned to my Lord Sir John Dyson, there will be circumstances in which one has to establish discreditable conduct without the benefit of a finding of fact by such a court, which constitutes prima facie evidence.
Mr. Bell, can I just ask a question to which I don't need an immediate answer?
I'm looking
at a finding of fact in a previous disciplinary proceeding by the Institute.
Yes.
Does that come under? Does it come under 3 C, and then is it one of the ones in 4? 'Cause it's not one of the ones in 5. I'm only asking because I just want to see how issue estoppel is dealt with so far as the Institute is concerned. So I don't need an immediate answer.
Yes, I've got to consider whether it falls within any of the bodies. It's 4C, and yes, it's not going to be 4. It's not going to be 4G because that refers to institutes of chartered accountants elsewhere in the jurisdiction.
Yes.
The answer to those instructions is they certainly don't consider that it does fall within that, but we'll see if we can confirm that. So can I then, as it were, to perhaps have the matter put more fluently than I've been able to do?
Well, you see in 6, just noticing it refers to the Institute there, sub 6.
Yes. At any accountancy body
Other than
the Institute, that tends to suggest that the provisional answer that I gave to my Lord Collins is likely to be correct. Indeed, yes, it would make no sense if it were not correct. Can I just take you to the way in which the Court of Appeal dealt with these matters? Because they, again, in our respectful submission, aptly stressed the difference between a 7.1 and 7.3 case. If your Lordship then goes back to sub 2 of 6, at page 7 in particular, there are 3 paragraphs which I wish to draw your Lordship's attention to in the decision of the President of the Queen's Bench Division, which the other members of the Court agreed. At paragraph 15, the reference has been made to Connolly and to those parts of the principles of Lord Morris which have survived, as it were. And just as to the 4th principle, it matters not the context in which this is uttered, it's the conclusions that are reached. 3 lines at the end. It is plain, said the President, that in the present case, the evidence in fact necessary to prove what was alleged in the conviction complaint would not establish what was alleged in the conduct complaint, and vice versa. Proving the conviction would not, in this case, establish the conduct complaint. Proving the underlying conduct would not establish the conviction complaint. And then if one goes to 16, again, taking it only the material passage, if one goes 8 lines or so from the end of the page, that paragraph, starting in my view, do my lords have that?
Yeah.
In my view, although the first tribunal found as facts a summary of the facts underlying the conviction, the appellant could not have been found guilty of discreditable conduct upon the conviction complaint by proving these underlying facts. The only basis for conviction on this complaint was by proving the conviction. This is because the only particulars alleged in that complaint comprise the conviction, and because the investigation committee's written submissions which form part of the complaint were limited to relying on the conviction. The complaint could not have been amended in the absence of the appellant, even if there was power to amend such a complaint, which is doubtfully refers to a case of Gorloff, decision of Mr. Justice Jackson, as he then was. And then finally at 20, in my judgment, applying Lord Devlin's principle in the present case, I mean, all this is on the basis that one's concerned with autrefois acquit, but the same principle applies in the civil context by which we raised judicata. The conduct complaint did not charge the same offence as the conviction offence. Both complaints were admittedly brought under the same bylaw and arose out of the same nexus of fact. And I think it's that, in a sense, that's been troubling my lords, but we say that actually those concerns will be met when one analyses with precision what was involved both in the bylaws and in the complaints themselves. But the discreditable conduct alleged in the first indictment was being convicted on indictment. That was both conclusive evidence of discreditable conduct, but also comprised the discreditable conduct. The discreditable conduct alleged in the conduct complaint was attempting to ship the forbidden documents, etc., out of Jersey. The facts relied on were not the same, nor were the legal characteristics, because what was alleged under the umbrella of discreditable conduct was not the same offence. As Mr. Justice Owen correctly observed, The mere fact of conviction on indictment would have constituted discreditable conduct without proof or consideration of the underlying conduct, if, of course, it had satisfied those three criteria.
But it was the underlying conduct which was the discreditable conduct, wasn't it? You say it was the conviction that was the discreditable conduct.
I do.
But
You say it's both. I mean,
Well,
that's what the
actually, I say,
President has said.
I say it's both. But what I'm saying to my Lord Clerk is, in relation to the first complaint, it was the former, not the latter.
And how do you read what I don't understand about this, I still don't understand how you read the language to reach that conclusion. I just don't understand that at all.
Well, my Lord, I'm afraid, my Lord.
Well, maybe we'll have to disagree about that, but...
Well, it does appear.
and you can see that from Regulation 7.
Well, we obviously construe it, my Lord, in different ways. I hope, actually, with great respect, it's made graphic when one gets back to look at the complaint, because unless actually the complaints if they don't track the language of the bylaws and the sense of the bylaws, they're incompetent as complaints. We say they do, and one can see exactly why the Court of Appeal considered, and the President considered, they were different. But can I just conclude the reading, then go to the complaints, which is in fact the next point of what I'm going to contend before my Lord. Yes, I've just read what the approval of Mr. Justice Owen. That by itself is sufficient to show that the principle of ultra quid did not apply. The conclusion is strengthened by the fact the appellant was not, as I've shown, at peril of conviction. One can leave that for the underlying conduct and the facts necessary to establish the conduct complaint would not have established the conviction complaint and vice versa. I would reject Mr. Jones's submission that the conviction complaint alleged only the underlying conduct. That's the position that my Lord Clerk is presently accepting, but we with respect dispute, and that the reliance on the conviction was no more than an evidential shortcut to establishing the conduct. With great respect, that's not what 7.1 says. It doesn't make any reference to the conduct at all. The fact of the conviction is that which is said to be evidence of commission of a discreditable act. My Lord is reading it.
Well, can I just put the point as I see it at the moment, so you can tell me I've got it wrong, no doubt. But what the conviction is conclusive evidence of the commission by him of an act or default mentioned in 4.1a.
Yes.
And so it's the commission of the act or default in 4.1a, which is the conduct.
Yes, it is.
And the only role of the conviction is as evidence.
Yes, it's as evidence of an act of discreditable conduct.
Yes, but it's the act of discreditable conduct, which is, and indeed it's the only thing which could be a breach of Article 4.1a, because that's what 4.1a is about.
Of course. But, my Lord, it's obviously inadequate. It's inadequate to say that every complaint, and this must be true of every complaint, as it were, which isn't in the other of the 4.1 categories, is a complaint of discreditable conduct. One has to look at the particulars to see what it is that's being charged. Here, the first complaint, and I'll come to this in a moment, doesn't refer to the discreditable conduct. It refers, as the rule or article entitles it to refer to, simply to the conviction.
Mr. Bell, going back to 7.1, it's evidence of an act of or default, as is mentioned in bylaw 4.1a. So could you please tell me, at any rate, what is the act or default mentioned in 4.1a?
Well, I say it's the fact of being...
Just go back to the wording of it.
Yes. I simply track the language of 7.1 itself. The fact that the member has, before a court of competent jurisdiction, been found guilty of an offence.
No, but what is going, just passing 4.1a,
Yes.
what is the act or default he has committed?
7.1 makes it clear that they equate the fact of being convicted with an act constituting discreditable
So we
conduct.
simply have to just decide whether that's right or wrong, that submission. I mean,
Yes.
one can...
I mean, it may not have been the most felicitous way in which it's done, but that's what they have sought to do. And they've achieved that. They say, you look at the fact of conviction, ergo, you have a discreditable act. And that's all. And if you have to ask what's the discreditable act, you're thrown back on.
But I suggest to you that it's quite clear what it is, and the answer is failing to comply with the direction issued on the date. That's the discreditable act. And it's proved, in an appropriate case, by the conviction.
Mr. Beloff, do you say that on the second complaint, the conduct complaint,
Yes.
do you say that if, supposing that had been the way it had been formulated first time round, yes, and they turned up, and supposing that there were a corresponding offence, let's just say it was an England and Wales situation, and they turned up with a conviction for an indictable offence, and the indictable offence was exactly that offence as set out in the complaint, slammed it down on the table and said, that's it.
For a complaint based on
in
conduct.
that he did on 22nd of December, blah, blah, blah. And here you have a conviction for, in the terms certified there, slam it down on the table and say, that's it. I've proved it.
I've proved the conduct?
Yes.
Is that the question?
Yeah.
No.
I proved the complaint. That's it. Because I've used 7.1, which is the key to the whole thing.
I would have proved the complaint for the purpose of the conviction complaint if there had been the corresponding
Yes,
offence.
I'm not
But if
asking
my
for
Lord's asking,
Yes.
let's assume
Yes.
that one has the conviction by etc., would that prove a conduct complaint? No. The
So it
answer
wouldn't
is no.
prove that on the 22nd of December he did that.
Absolutely.
It wouldn't be conclusive proof of
It
that.
would certainly not. And
Why not?
Because 7.3 makes it quite clear that one then has to look at
No,
the
but
findings of
7.1
fact.
makes it clear. The prosecutor would say, or the institute would say, well, here's the conviction. We've alleged paragraph 107, here's the conviction. As my Lord said, that's all the prosecutor would have to do.
Yeah, 7.3's got nothing to do with it.
I mean, the truth is there are three ways of proving the underlying complaint. One is by, in an appropriate case, by Section 7, Article 7.1, which provides for conclusive evidence. The second way is insofar it applies by 7.3b, and the third way is by calling a chap to say he saw it being done. Surely. With great respect to the President, he's simply wrong about it.
Well, I mean, you're not, it has advantage ability to say that, but I'm afraid
consider the argument, of course.
I must resolutely adhere to the fact that your Lordship builds into that the proposition that what 7.1 is concerned with is proving the underlying conduct in cases where there have been all three of those criteria satisfied. And I say no, they don't need to go that far. They don't need to argue we've proved the underlying conduct. They simply slap it down. That's a conviction. It's a trump card. If they needed to prove the underlying conduct, then no doubt they would have to develop a little bit more.
Well, I think you've stated your proposition as clearly as it could possibly be stated, Mr. Beloff.
Not a very encouraging observation. I'll take it for what it's worth, for small mercy. My Lord, perhaps I can I just, I mean, what's clear, what we say, of course, is that for a conduct complaint, you need to prove, in this particular instance, three matters: the direction, the awareness of the direction, and the breach by the taking of the documents out of the jurisdiction contrary to the direction. I say with respect that, I mean, that involves something other than proving the conviction, establishing the conviction. Can I then just look, if we may, then just let's look finally at the complaints before I pass on. Yeah. Because in our respectful submission, the complaints track perfectly the analysis that I've advanced. If you look at 9, which is the conviction complaint, your lordships will see that, again, like anything under 4.1a, it starts with the saying you're liable to disciplinary action because you committed a discreditable act, I paraphrase. How is that established? It's established by the words "in that," and then what is it? It's that you've been convicted on indictment of failing to comply with the direction, etc., etc. Then if one looks and contrasts this at 12, sorry to be repetitious in relation to this matter, it's obvious to some considerable importance. If one looks at conduct complaint at 12, one sees that there's no reference to the conviction at all. There's simply reference to the facts which gave rise to the conviction, which then would have to be established independently by the findings of the Jersey court, together with any other admissible evidence that was sought to assist, since the findings of the Jersey court were only prima facie evidence. With great respect, the contrary analysis, which your lordships appear presently to find acceptable, pays no heed at all to the language of the complaints. The complaints are identified by their particulars, and they are distinct. And in respect of the first, require a reading out of certain words. This was my Lord Clerk's starting point before the adjournment, that was convicted on indictment a surplusage. One could go straight to failure to comply with a direction. The answer is yes, one could have had a complaint of failing to comply with a direction, but for that purpose the conviction would have been inadequate.
The advantage of referring to the conviction is that it tells you, it gives you particulars of the failure to comply.
Well, there's an advantage.
Otherwise, to my mind, it remains an immaterial event.
But it describes the offence.
Whether you're right or wrong on your proposition that being convicted is a separate item of conduct can't depend upon what the draftsman put as particulars of the offence.
No, there has to be a symmetry between the bylaw and the complaint. In other words, the distinct complaints have to reflect distinct concepts in the bylaws. That is the point that I made. I merely say they graphically illustrate that particular distinction.
At tab 12, can we just see what was placed in the summary at paragraph 8 at page 109?
Yes.
In November 2004, the committee preferred a complaint alleging that the defendant had been convicted of an indictable offence and that therefore he should be liable to disciplinary action. The IEC sought to rely on bylaw 7, which provides that a conviction of an offence corresponding to one is conclusive evidence of the commission of that act.
Right.
What act?
Well, my lord, that's the way in which it's put there.
Yes.
It's not very happily.
Not very happy.
It's not, well, my lord,
It's correctly put.
No, what I say with respect is incorrect. And there's a great deal in the so-called decisions of the tribunal that I would quarrel with as being what one does know, however, if I may, as it were, put a card in juxtaposition to the card that my Lord the President has played. The last sentence, the IC does not rely on the fact of the conviction in the present case. That is consistent with my submission, and in a sense it's inconsistent with the sentence that my Lord referred to.
The IC does not, on this occasion, seek to charge. That would have been consistent with your submission.
Well, they're not relying on the fact of the conviction
To
at
prove
all.
the commission of the act. Well, Mr. Dolphin, I don't think it's profitable.
Could I just wonder, no, it's not going to take, I just wondered, since we are looking at the forms of looking quickly through the bylaws, I couldn't find much which really seemed to specify what's to go into a complaint and what's not. I mean, I can see these have all been drafted according to some sort of precedent that's been developed, but do the bylaws specify what's to go into?
No, there may be guidance. There's some guidance.
There is some guidance, yeah.
Yes.
But there's nothing specified.
So we respectfully submit that both in form and in substance, the two complaints are in fact distinct. And perhaps I do end by saying this, although I suggest that this bylaw is drafted particularly tightly so as to need to avoid even consideration of whether being convicted of an offence is something that is itself discreditable conduct. It answers the matter for you. I do remind your lordships he's very familiar in disciplinary codes of this kind to make the fact of conviction an offence. And there's no reason why, your lordships, as long as you consider that the language admits of this, to suggest that the Institute have in fact adopted a uncharacteristic posture in that regard. In fact, it would seem very unlikely for that to be the position.
Well, the obvious place to make that clear would be in 4.2, wouldn't it?
Yes, well, they could have...
They obviously, the draftsman chose not to do that. He chose a different method.
I understand what your lordship sees the matter.
Only as a Sedilla, I'm not sure it would make any difference. Even if we were looking at one of these offences which said it is an offence to be convicted of an indictable offence, full stop. I suspect the same arguments could be marshalled if, having dealt with you for being convicted of an indictable offence and punished you, you then sought to bring further proceedings, you'll be met by autrefois convict.
My lord, I have enough problems
Yes.
with the as they
Anyway.
are, rather than
Anyway.
dealing in these hypotheticals.
It wouldn't work the other way, actually.
Well, my lord, in any event, I think your lordship has been gracious enough to say at least you have my submission, whether you accept it or not. Can I then turn to point 6, because point 6 again is going to require just a little analysis. Just assume, as is possibly your lordship's correct collective present view, that the complaint at 9 is construed as being, as it were, a proxy of, or indeed a conduct complaint in itself. The question then arises, has there been a decision on the merits in relation to that underlying conduct? That's to say, the removal in breach of the direction of the critical documents from Jersey. And for that purpose, one needs to look at the decision itself, which is at tab 11 in the same section.
If the arguments had been the same, but the decision had been the other way, then it would be a decision on the merits, would it?
No, I say there's no decision at all on
No,
that
but
particular issue.
No, and I understand you say that at the moment, but if the argument had been the same, the transcript of the argument was precisely the same, and the only difference was that they found the case proved, as say they accepted Ms. Peto's argument, then that would be a decision on the merits, would it?
Well, I would say it would be a decision on the merits. That's to say they'd found 7-1 and 4-1 satisfied in conjunction, yes.
So, but your argument now is that a decision that it's not satisfied is not a decision on the merits.
No, because your lordship, as it were, assumes that what I'm saying when using the word merits, I'm at one with your lordship in relation to the question that it was a conduct complaint. But I mean, for the present purposes, my lord, on this argument, I have to assume that is right. I have to assume that is right, and then one just simply has to look to see what it was that happened. Well, first of all, as your lordships know, all that the ICAEW had was the conviction itself. One sees at 96, I just remind you, it's the only one that passage one needs to take you to, of the transcript of the argument. Miss Peter, who had the carriage of the argument, says this is a matter that is brought under disciplinary bylaw 41A, and it's based on the defendant's conviction as being read out on the indictment before the Royal Court of Jersey on the 16th of September. If I'm able to satisfy you that the conviction falls within disciplinary bylaw 71, that's conclusive proof of an offence under bylaw 41A. I don't want to repeat myself, but I'm just saying it's drawn like that, you don't need to consider anything further. Then, without more ado, you're entitled to find the defendant's conduct has brought discredit and is liable to discreditable action. So that's all that they had, and they didn't have a material, we say, because under the rules, the conviction and findings of fact underlying the conviction are designedly made distinct. They were not therefore asked to find conduct proved on that basis, nor indeed did they so find. If one looks at what one would call in community parlance the dispositif of this particular determination that one finds at tab 11. What are they? This is under the tribunal were satisfied. Now this is,
and indeed we have the oral finding, don't we, apparently page 14.
yes, but it's the
Then
it's identical.
Yeah.
This is just the formal document. I'm happy to go to either. There is again a great deal of what we respectfully submit are surplusage in this, again, but when one looks at what was the dispositif, it starts with the words at 105, the tribunal were satisfied, the defendant was convicted on indictment, etc. So that's a fact and a conclusion they reached. Then it says they noted that it was alleged and not disputed that jointly with his wife he was caught by the police, removing from the jurisdiction of the Jersey authorities original documents and records concealed in the back of this car in breach of this requirement. Well, now there are 2 points. I mean, first of all,
This is not the sort of conduct that is to be expected from a member of this
I'm not going
institution.
to ignore it, my lord. I just want to read the sentences one by one, if I may. The next point, the 2 points, actually, first of all, it's not by any means clear that it's not disputed. Because if one looks at the so-called findings of fact, paragraph 6 above, one sees that the defendant is saying that notice of crime was not served on him personally, and he intended to make a further appeal against the conviction. So, but more importantly, quite apart from that seems to be slightly inaccurate, they say merely that they noted, and that's obviously distinct from making a particular finding, which is used by the words they were satisfied. Then going on, this is not the sort of conduct that is to be expected of a member of this institute. They are scrupulous to avoid finding that there was a conduct constituted a breach of 4.1a. They obviously weren't able to restrain themselves from on the assumption that those facts were made out, that it would be discreditable conduct, but they realized they weren't being asked to and were in no position to make findings in relation to that conduct. Then they went on to say what they had to be satisfied about, that was the corresponding offence. They set out the provisions that were said to correspond, and they concluded they were not satisfied that any of the offences set out in these sections correspond to the offence of which he was convicted in Jersey. Now, in our respectful submission, they simply didn't address the conduct as such at all. Their mind were entirely focused on the issue of whether or not the conviction was sufficient because it satisfied the 3 criteria.
But that's because of the way in which the case was put.
Yes.
I mean, this was a hearing.
Yes.
If you go to page 104, they say about just above halfway, the tribunal, because there had been an application to adjourn this hearing.
Oh, yes. That's frequent.
In all circumstances, they considered they should hear the complaint. So
Yes.
they were hearing the complaint without further postponement. They proceeded with the hearing on the basis the defendant denied the complaint. Then they set out various facts about the convictions and so on. And then on the basis of the way in which the charge was being presented, they dismissed it.
Yes.
Well, why isn't that a hearing on the merits, on the basis of the way in which the case was put?
But it may be that the way I'm putting it under my 6th submission is merely reflecting back on the way I put it under 5. What I say is they never address the question, did he in fact remove these documents
So
from
that
Jersey
begs the
and breach
question
the
of
direction.
whether the failure to address that question is a failure to deal with the merits, such as not to attract the principle of res judicata. That's the question.
Well, in which case, in a sense, 5 and 6 are interwoven.
Yeah.
But I'm just saying this is another graphic illustration of the way in which they never engaged with the underlying issue because they didn't consider it was before them.
They proceeded on the basis that your construction of rules 4 and 7 is the right one.
Yes.
Although they did engage, maybe, on the underlying. As far as I can see, the irony of this whole case is that there isn't any dispute but that, one, there was in such a direction, 2, these documents were in his car, 3, he was arrested, and the only issue before the court before was his only defence was he wasn't notified of the direction. That was the only issue at the trial.
Which was something that's been found against him by the Royal Court.
And
when he hadn't scrupled to give evidence himself. No, I agree with that. All I'm saying is if one asked the question, if someone said, looking at this determination, have this tribunal actually addressed the issue of whether or not he removed these documents from Jersey and breached the direction, the answer would be no. They haven't addressed it. And indeed, they recognise that they're not addressing it, because insofar as they flirt with the matter, they do it in sentences such as they noted and in our view. What they're not doing, with that which they would be doing, if the conduct were in focus, to say we find these as fact and this is discreditable conduct.
Well, that's because your clients didn't invite them to do that.
No, they didn't.
So why do you say they've not engaged in it? I mean, they found the following facts. And 4 contains a thing about further direction was necessary to prepare a plan, blah, blah, blah. He was arrested and so on, and all that. I mean, why do you say they weren't engaged in the conduct? These are all findings of fact.
Well, I'm obliged to say that they weren't being invited to make those findings. Therefore, it was simply surplusage. They were simply reciting matters that they found from the documentation. But, that's, I said, there's almost a disconnect. First of all, there's a disconnect between the so-called facts found and the way in which the charge was presented. Secondly, there's a disconnect between those facts allegedly found and the dispositif when they come to say this is what our determination is. And thirdly, that the determination simply does not make a finding of whether or not there'd been a breach of the Jersey, a conscious breach of the Jersey direction.
I mean, is this case any different from a case in which, let us say, a criminal prosecution had been brought, relying upon one witness who gave hopeless evidence and was rejected, and therefore the claim was dismissed. The defendant was acquitted on the one hand, and then later the prosecution found that actually they got a lot of excellent evidence which would have supported a conviction. And then they started a second set of criminal proceedings relying on that good evidence. Now, is that an unfair analogy? Because isn't what happened here really that there was an attempt to prove the act by using one piece of evidence, namely the conviction, that proved to be abortive. There, in fact, was a better route, and they sought second time round to adopt the second route. Now, why are those two positions not analogous?
I am conscious, my lord, that the Proposition 6, in a sense, is a reworking of Proposition 5. In other words, there's the dialogue between myself and my lord. We start from different premises. I say that their construction was entirely consistent with different routes to the same destination of discreditable conduct, but, as it were, what is the discreditable conduct in a 7-1 route and a 7-3 route is distinct. The 7-3 route would be the conduct underlying proved in whatever way 7-3.
But if your proposition 5 is not accepted,
yes,
do you have a discrete point based on the merits?
I think your lordship is right that it's difficult to say that it's a discrete point. It's maybe one just illustrates the way in which this was. I mean, my learned friend referred, for example, to the Senna Can I just, I think it's the only case under this heading that it's necessary to look at, because my learned friend, I think, rightly said it's the highest authority in relation to what is meant by a decision on the merits. It's tab 58. Could you get the volume on?
6.
As I say, it's a particularly attractive case, my Lord the President.
Yes, I observed that, yes.
But my Lord Clerk may be satisfied at a subsequent juncture. I'm going to come to a case in which he could hope to take some consolation from his observation. But in this particular case, my learned friend has taken your Lordship, I think, to the heart of the matter. Lord Brandon, who was consistent here with Lord Diplock, Lord Diplock said there's no kind of moral overtone to the concept of on the merits. He deals with that at 494 between A and C. Lord Brandon then deals with the matter at page 499, and he sets out a passage between F and H, which have already been read to my lords, as to what constitutes the decision on the merits. And then when one comes to what the decision there was, the argument in relation to the second contention, the first one, this is procedural, and that was dismissed, was that the issues in the Dutch Court of Appeal and the Admiralty Court here were entirely different. The issue in the Dutch Court of Appeal, it was said, was whether the appellant's claim could be founded on tort as distinct from contract, and if not, whether the exclusive jurisdiction clause contained in Clause 27 of the Bill of Lading No. 7 applied to it. By contrast, it was argued by Lord Nancy Murray, the issue in the Admiralty Court here was not whether the appellant's claim could be founded on tort as distinct from contract. It was indisputable on general principles of English law that it could. The issue was rather whether, even if the appellant's claim was framed in tort, it would still come within the exclusive Sudanese jurisdiction clause. And then, this was the decision, there was no substance in this alleged difference between the issues in the two courts. The issue in both courts was one and the same, namely whether, though the appellant's claim based in either case on the same facts, legal different analysis was framed in tort rather than contract. The exclusive jurisdiction clause in Bill of Lading No. 7 applied to such claims. So what we understand it, Lord Brandon was saying, is whether you start in Holland or whether you start in London, you are going to be faced with the same issue as the exclusive jurisdiction, Sudanese jurisdiction clause. You've lost on that in the Dutch court, you can't revive it. It's exactly the same matter in the English court. And we say there's just simply, for reasons I've already articulated, no affinity between that case and
Is really the distinction one between issue estoppel and cause of action estoppel. In the Senate, they were arguing about jurisdiction, not about the fundamental cause of action.
Yes.
Here, if the tribunal had said, right, we're going to, first of all, consider the shortcut, assume that it was being relied upon simply as an evidential shortcut.
Yes,
we're going to decide that point first, because if you win on that, there's no need for us to hear all the evidence that's lined up for tomorrow.
Yes.
So they hear the argument on the shortcut, and they rule against prosecution on the shortcut. That would be a final determination of that issue, per rem judicatum, if you like, creating an issue estoppel, but not a cause of action estoppel, because one could then go into the underlying merits. Here, however, there was no two-stage process.
Yes.
All the eggs were put in the one basket.
Yes. With the benefit of hindsight, which is always so easy, one would have said, why didn't they, for example, put the two in the alternative? Or if they'd recognised that they were facing an uphill struggle, which Miss Peto, unfortunately, didn't recognise till late, why not say, we're going to adjourn this and we're going to go through? Because, of course, if they'd taken the view that my lords are provisionally taking, that this was actually all about conduct from the start, it wouldn't even have needed, which they were worried about, re-going through the investigation committee to have a fresh complaint and re-putting it to Mr. Coke-Wallis on the basis of fair procedure. They could simply have said, if their analysis had tracked your Lordship's provisional analysis, well, there it is. We're not going to be able to succeed on this, so we're going to adjourn, and I'm afraid we're going to have to call these witnesses if Mr. Coke-Wallis insists on them being called. It's a great pity, in a sense, that...
And they're all very, very simple points, which could have been approved in the easiest possible way. I mean, there was no difficulty about any of the points.
No, it's true. Well, as indeed, as we know from the subsequent, as we know from the subsequent history of this matter, it is again. It's simply because they thought, and this is the last time I hope I say that all they thought was necessary to find discreditable act was the conviction, and that was it. Conviction equals discreditable act. End of case. Don't worry about anything else until you get to mitigation. The seventh point, which we've advanced really, the point that was my Lord Phillips raised in the course of argument with Mr. Jones as to whether or not, given that we are here in a realm which is distinct from either criminal procedure, but we are in the civil realm in any event, we are in a realm which is distinct in the sense that in civil proceedings, one is concerned with the interests of the two parties, the plaintiff and the defendant, claimant, respondent, call them what you will. Whereas in this particular case, the Institute are not actually acting in their own behalf, they're acting as a regulator in the public interest. When it was put to my learned friend by Lord Phillips, he said, well, there's no authority for that proposition. I would equally submit, actually, there's no authority against that proposition, and one wonders in principle why this should not be so. It's quite useful to look, if we may, at the Workington case, which is a classic example of cause of action estoppel. That's at tab 65. That was the decision of Lord Atkin. And you will recollect, my learned friend said that had a very close analogy to this case, because what was relied upon by the recipient of the services of the builders was an engineer's, it's a volume 7, was, as you will recollect, a engineer's certificate, and for various reasons that engineer's certificate was found not competent to provide the evidence of the breaches that were relied upon, and therefore resort was then had in the alternative or secondarily to proving the breaches by other means, and it was that Lord Atkin, in a speech with which the other members of the House agreed, was not open to them because of the underlying principle. If one goes to letter D at page 106, I'll just read the last passage. However that may be, the issues in the first action appear to cover every breach by the contractors and all the damage suffered by the Harbour Board in consequence, and are therefore precisely the same as those in the second action, which must therefore fail. The result is that the plaintiffs, who appear to have had a good cause of action for a considerable sum of money, fail to obtain it on what may appear to be technical grounds. Reluctant, however, as the judge may be to fail to give effect to substantial merits, he has to keep in mind principles established for the protection of litigants from oppressive proceedings. There are solid merits behind the maxim, nemo bis vexari debet pro eadem causa, the words that we're omitting from our 10 propositions. In the present case, the plaintiffs were warned over and over again the first action, the defendants contended they were not bound by the engineer's certificate. The plaintiffs chose, and in view of the complexity and expense related to the various alleged breaches, no one can call them unreasonable to take the risk and to adhere to the certificates necessary to prove they fail. The consequence is inevitable, as I think the defendants show that a plea of res judicata would succeed. It's been unnecessary to consider the further objection. The present action raises matters which might have been included in the former action, but I'd first say nothing on this point. Now, on the assumption that your lordships adhere to the view that the first complaint in these proceedings, the Coke-Wallis proceedings brought against Mr. Coke-Wallis, were the same as those in the second complaint, and that the Institute did not pay heed, it's a matter I'll come to at a later stage, but not pay heed to the fact that Mr. Coke-Wallis had advised them of the very defect in the complaint, which the tribunal in the first instance acknowledged, then one can see, of course, the close affinity between that case and this. But it's interesting to note that Lord Atkin does appear to recognise that substantial merits may play a part, and he recognises, of course, that it's trumped in the circumstances of inter-parties private litigation by the importance of the maxim. In our respective submission, there's no reason why one should not create an exception to give effect, not as it were to the substantial merits, as it were, of the second case, because for reasons one come to under the abuse of process heading, that appears to be something that one must not take into account. But, as it were, what I call the broader merit of allowing the matter to proceed in the public interest. And there's nothing in this which I would regard as the hallmark case, the sheet anchor case of my learned friend's submission, that's actually inconsistent with allowing that degree of exception in circumstances that were not within the purview of the House of Lords in that case. I can't put the matter any further. Your Lordships have, for example, Lord Bingham, then Master Rose, Sir Thomas Bingham, the classic statement in Bolton about the purposes of the disciplinary proceedings in regulatory bodies of that kind. That's the motive force to create
if that were right in principle, one would then have to consider in this case whether, having regard to the facts, the public interest really did require this to be reopened.
Oh, that is true. No, that is true. But at the moment, I have to persuade your Lordship that there isn't, as it were, that opening to consider in the same way as in relation to the abuse of process.
The slight difficulty I've had with this argument, which I find quite attractive, otherwise, is, of course, that if one thinks of something which is even worse or more, where the public interest is even more engaged, one might say, in the criminal sphere, if, to take the kind of example Lord Sir John Dyson was giving, I mean, if the prosecutor makes a mistake, he doesn't get a second bite of the cherry, and that's it. And life as a prosecutor would have been much more relaxed if one had felt that if one dropped the ball, one could pick it up again and start all over again. You can't. Now, why, if you can't do it in something which is even more significant for the public interest, why should you be able to do it here? That's just all I was asking.
Yes, well, there are two matters. I mean, first of all, although we haven't, as it were, gone into the detail of the doctrines of autrefois, convict and acquit in this appeal, that we're resting, as it were, with the written submissions which appear to be consensual between the parties. What actually was omitted from our analysis, but was something I was going to bring to your Lordship's attention, is that in that sphere, what is particularly thought to be relevant is that the state has coercive powers. It's because it's the state, they should not be allowed a second bite at the cherry. They should not be allowed to use all their endless apparatus against a defendant. That's the first point. And the second point of distinction I would make is the very point that is made in the Bolton case. I'll refer your Lordships to it, I'm sure you know it very well indeed, in which Sir Thomas Bingham, as he then was Master of the Rolls, said the purposes of disciplinary proceedings and the purposes of criminal proceedings are distinct. Although, of course, it is true that in criminal proceedings, a byproduct of a prison sentence is that the malefactor is removed from the open and therefore no longer able, while in prison, to commit the offences. The primary purpose is regarded as punishment, redress, penal sanctions for the offence committed. Whereas, by contrast, although there is a penal element in disciplinary proceedings by a regulator, the major objective is, in fact, to ensure, especially in the sphere of professional persons, that persons who are not fit to practice, my Lord, the President instance, airline pilots as well, one can think of other instances, that they should not be able to. So those are two differences that I would seek to rely on to justify the creation of that distinction. The other matter, which I'm reminded of, there is a third, and in fact it was referred to, I think, by Lord Justice Simon Brown, as he then was in one of the cases. I think it was Redgrave. It matters not, but the point is well made, without the support of eminent authority, that the one sanction that a regulator cannot impose, of course, is a loss of liberty. And therefore, important though the sanctions are, they pale into insignificance compared with that. So there are those 3 points of distinction that I would regard as creating a principled exception to the...
Now, this is a point which hasn't been discussed in any of the cases.
No, that's what I'm saying. My learned friend said no case in favour of the proposition. I say there's no case against it. Let's look
Would it work both ways? I mean, could somebody on the other side, the individual, could say, well, it's in the public interest that I should be allowed to continue. It's true that this tribunal heard this matter against me some time ago, but I've got some better evidence now, and I'd have another go.
Well, that's that's
Presumably it would.
different, because that fresh evidence is an issue going then to the merits.
Well, this is
of the
fresh evidence
matter.
in a way. I mean, it's not fresh evidence because we had it all along.
Well,
It's not even a fresh evidence case.
no. I realise I won't say anything, as it were, more as far as that aspect.
I mean, you might say there's a considerable public interest that regulatory authorities should put their eggs into one basket and not oppress members of the profession
that's what
the underlying principle the other way.
That's what Mr. Jones says. Yes, and Mr. Cole says, and one scene they put it very eloquently in their printed case. We've got to, as it were, juxtapose that and ask which is the superior public interest.
Well, there is a public interest the other way, or maybe in perhaps...
Yes, and that's an evaluative matter, and I shall come to the fact that as it were, the evaluation has been carried out at first instance and as the Court of Appeal. Yes.
Would this be the same exercise as this proposed exercise, the same exercise as in an abuse of process case, or a different one?
Yes, no, it'll be the same exercise.
The same exercise.
Fundamentally the same exercise, yes. The reference to Lord Justice Simon Brown then was judgment is in the Redgrave case. It's tab 33. It's page 1146, paragraph 38. I don't trouble your lordships with it. I accurately recollected, or was reminded what he said. Can I then come to the penultimate proposition, and we can, I think, take this quite shortly. In our respectful submission, and I don't understand there to be much dispute about this, but if there were dispute, it's ill-founded. The law in this area divides into pre and post the Johnson-Gore case. And that case, the decision of the House of Lords, has been applied in many cases since it was the speeches of the House, and we've referred in paragraphs 91 and 92 to a list of cases in which Johnson and Gore Wood was referred to, and we've noted that in some of the cases it has been said, at any rate at the level of the Court of Appeal, there is simply no need now to revisit the previous law, and that's the position that we ourselves adopt. That being so, can I take your lordships then to the Johnson and Gore Wood case? Yes, it's in the first volume. Is it the second? Volume 2, tab 19. Because my learned friend, first, with great respect, simply misunderstood the critical passage in the speech of Lord Bingham, and secondly, didn't draw your lordship's attention to an equally important passages in the speech of Lord Millett. If I can just take your lordship to page 31 then, which has been read before, and I'll just go, if I may, to the letter C, in effect. Let's letter B. The bringing of a claim or the raising of defence in later proceedings may without more amount to abuse if the court is satisfied, the onus being on the party alleging abuse. The claim or defence should have been raised in the earlier proceedings if it has been raised at all. I would not accept it's necessary before abuse may be found to identify any additional element, such as a collateral attack on a previous decision or some dishonesty. But where those elements are present, the later proceedings will be much more obviously abusive, and there'll rarely be a finding of abuse unless the later proceedings involve what the court regards as unjust harassment of a party. And I do stress Lord Bingham's use not only of the noun, but of the adjective as well. It is, however, wrong to hold that because a matter could have been raised in earlier proceedings, it should have been so as to render the raising of it in later proceedings necessarily abusive. That's to say, maybe it may not. That is, Lord Bingham reinforces the point, to adopt too dogmatic an approach to what, in my opinion, should be a broad, merits-based judgment which takes account of the public and private interests involved and also takes account of all the facts of the case, focusing attention on the crucial question whether in all the circumstances the party is misusing or abusing the process of the court by seeking to raise before it the issue which could have been raised before. I found my learned friend's analysis of the distinction between prospective and retrospective analysis somewhat elusive, but what I do say is it's quite clear that Lord Bingham says the moment at which one needs to consider whether or not the second set of proceedings is abusive is when one comes to the second set of proceedings and asks at that circumstance, taking account of all the private and public interests involved, is it abusive at that stage to continue with this second set of proceedings? Then, as he goes on, as one cannot comprehensively list all possible forms of abuse, so one cannot formulate any hard and fast rule to determine whether on given facts abuse to be found or not. So it's essentially a fact-sensitive matter involving an element of judgment, and that's a point to which I'll return in a few moments. And then what he does, he gives certain examples which are not engaged here, and then at F he says, while the result may often be the same, it is in my view preferable to ask whether in all the circumstances the party's conduct is an abuse than to ask whether the conduct is an abuse, and then if it is to ask whether the abuse is excused or justified by special circumstances. So that's where, in a sense, he relegates to the oubliette of legal history the previous analysis, which says you start with one, then you look for the exception. He says that, and the House of Lords agree that that's not now to be the correct approach. Lord Millett, at page 59, refers between D and E, of course, to the prima facie right of access to a court conferred by Article 6 of the Convention. And then he goes on, while therefore the rule of res judicata in all its branches may properly be regarded as a rule of substantive law applicable in all save exceptional circumstances, the doctrine now under consideration can be no more than a procedural rule based on the need to protect the process of the court from abuse and the defendant from oppression. I only pause there to note that, of course, the exceptional circumstances previously recognised in jurisprudence obviously don't encompass the exceptional circumstance that I'm now seeking to introduce into the formula, that's to say the public interest, but it is a recognition that the law hasn't been adamant in saying that res judicata end of story. Then between G and H, the question must be determined, yes, there is only one question considered in the present case, whether it's oppressive or otherwise an abuse of the process of the court for Mr. Johnson in his own proceedings against the firm when he could have brought them as part of at the same time as the company's action. The question must be determined at the time when he brought present proceedings and in light of everything that had then happened. Now, when he brought the present proceedings, again, that focuses on, in this instance, the second set of proceedings. Then he says, could have, does it mean that he should have, or that his failure to do so renders the present action oppressive to the firm or an abuse of the process of the court. So there one has it articulated very clearly. The fact that one could have and should have and should have, may be a necessary ingredient of a claim for abuse, but it's not sufficient. One has to go on and look at other matters. And then he goes on very much in the same form as Lord Bingham. And we deal with this at paragraph 69 of our printed case, where we set out a series it's not 69, forgive me, it's 89. As usual, my handwriting lets me down. We say that the following propositions, this is page 28 of our printed case, the following propositions can be derived from Lord Bingham's and Lord Millet's judgments in Johnson, or speeches in Johnson and Gore Wood. First, there's no presumption against the bringing of successive proceedings. Second, the burden of establishing abuse of process lies on the party alleging it. Third, it is wrong to hold that because a matter could have been raised in earlier proceedings, it should have been, so as to the raising of it in later proceedings necessarily abusive. Fourth, the question in every case is whether applying a broad merits-based approach, the conduct in bringing the second action is in all the circumstances an abuse of process. This involves a balancing exercise which takes account of all the facts of the case, as well as of all the public interests and private interests involved. Fifth, the court will rarely find the second action's abuse of process unless it involves unjust harassment or oppression of the defendant. And sixth, it's inappropriate to adopt a two-stage analysis of considering first whether there's an abuse, and if so, then to ask whether the abuse is justified by special circumstances. That would be too restrictive an approach, which would risk shutting a party out from bringing forward a genuine subject of litigation. And in our respectful submission, that is a fair analysis of the speeches. There's only one other case it's necessary to refer to under this heading, and then I will come to the penultimate submission, and that is, of course, Goldberg-Linda, which is at tab 55. And again, my learned friend, with great respect to him, has misunderstood the effect of this case. This was a decision to which my Lord Clark, then Master Rolls, participated. It's necessary, which my learned friend omitted, to identify what the particular issues were. It's insofar as my learned friend says that this is a case which justified exclusion of considerations of the public interest from the formula contradicting, as we would respectfully submit, Lord Bingham and Lord Millet. The issue wasn't even raised. Paragraph 26, page 832, Lord Justice Lloyd, who gave the first judgment, he says the appeal seems to me to raise three general points which deserve examination as to whether they're properly been taken into account in considering whether a second claim is an abuse of process. So far as I know, they have not featured in previous decisions on the point. They are these. Is it relevant to consider the prospects of success or otherwise the second claim, or B, the promptness or otherwise which the second claim has been brought, and if the claimant explains the failure to include the second claim in the first proceedings by reference to not having known relevant facts, time of the first proceedings, is it relevant to consider C, whether he might, with reasonable diligence, have found them out in time. Now, none of those issues, of course, touch at all upon the question as to whether one should exclude public interest considerations from the matter. All that Lord Justice Lloyd decided was that in looking at the merits, one should not concern oneself with whether or not the second case was likely to succeed. That's what he deals with at 839 under the rubric prospects of success. And I simply draw your Lordship's attention in that to a passage which has not actually featured either in our printed case or indeed in my learned friend's submissions, having cited at the outset of paragraph 57 Lord Bingham's emphasis on the broad merits-based judgment. Lord Justice Lloyd goes on to say, just before letter G, it's necessary to proceed with care in relation to a contention that some aspect of a particular case must be regarded as irrelevant in principle. And then he goes on to say, however, merits are in fact to be, the potential merits of the second set of proceedings are to be excluded from the equation. But otherwise, he says, we'll be very careful in saying that something isn't going to be relevant given the breadth of Lord Bingham's dictum. My Lord, then the Master Rolls, and now Lord Clark, said at page 78 that you adopted the account of history. And then if one goes to paragraph 98, my Lord, in a sense, epitomizes and summarizes the way in which the House of Lords had then advised that matters should be approached. Notwithstanding the views I've expressed, this was undoubtedly a usual case. The question is not simply whether the claimant acted unreasonably in not raising the inducement claim in 2000, or indeed whether his failure to do so was an abuse of process. The question is whether the second action is an abuse of process, which involves a consideration of all the circumstances of the case judged as at the time the second action was brought. And that, with great respect, gives the lie to my learned friend's submission that one somehow looks back simply to the first set of proceedings and blinkers oneself in relation to what happened thereafter. The last case I wish to refer to, if I may, since my learned friend did repose some emphasis on it, is the Walton and Gardner case, volume 8, tab 79, because in our respective submission, this was again a case which actually reached the opposite conclusion to that with which my learned friend contended. My learned friend used this case, you may remember the tragic circumstances of the Australian surgeons, to suggest that the public interest in continuing disciplinary proceedings should be excluded from the equation. But with great respect, that's exactly what the High Court of Australia did not say. And again, not to weary your lordships overmuch, just take your lordships to the last paragraph of the conjoined majority judgments of the Chief Justice, Mr. Justice Dean and Mr. Justice Dawson, at 396, before they come to the double jeopardy. What's said a third of the way down the page, and perhaps let's go a little bit above, the question whether disciplinary proceedings in the tribunal, in fact, in tribunal should be stayed by the Supreme Court on abuse of process grounds should be determined by reference to a weighing process similar to the kind appropriate in the case of criminal proceedings, but adapted to take account of the differences between the two kinds of proceedings, which in short form I sought to answer in response to a question by my Lord Roger. And then going on in particular in deciding, and this is one of the differences, deciding whether a permanent stay of disciplinary proceedings in the tribunal should be ordered, consideration will necessarily be given to the protective character of such proceedings and to the importance of protecting the public from incompetence and professional misconduct on the part of medical practitioners. So that's the difference that's identified, and it's that difference which the High Court of Australia said that one had to take into account the importance of that. And one would say for medical practitioners, read accountants, read lawyers, read any other professional person. So that's entirely inconsistent with my learned friend's submission. Then the next sentence shows what the ratio of the High Court of Australia's decision was. As we read their honest judgments, that's in the Court of Appeal, the members of the Court of Appeal all utilised such an adapted weighing process in the present case. So all they were there saying is, as long as the appellate court, no doubt the court of first instance, took account of this highly material consideration, the protective character of such proceedings, and made their own evaluation of it, we, as the High Court, analogy here, the Supreme Court, cannot interfere with that particular judgment. And what we say is, without wearying your lordship and just giving your lordships the references, Mr. Justice Owen, in paragraph 44 of his judgment, and the Court of Appeal in paragraph 26 of their judgment, both evaluated, on the one hand, the concerns of Mr. Coke-Wallis, that he was being faced with a second set of proceedings, and on the other, the public interest in protecting against incompetent or even dishonourable accountants. Both of them evaluated the matter on the basis the scales tipped in favour of allowing the second proceeding, so there was no abuse of process. And in our respectful submission, according to a well-known principle exemplified here in the Australian High Court, this court will not interfere with that exercise of judgment. So I come to my...
Did they make it clear that they were taking into account, on the other side of the scales, the nemo debt principle?
Yeah, well, shall we,
I mean, I'm looking at paragraph 26 of the Court of Appeal.
Yes.
And they emphasise that this was an evidential technicality.
Yes.
Twice talk about a technicality and a technical error.
Yes.
In fact, 3 times the word technical appears. It is not, in my view, 4 lines from the end, in the public interest that this technicality should prevail.
Yes.
There's nothing unfair, unjust or oppressive in bringing the second conduct complaint.
Yes.
And there's a compelling public interest. I mean, where do we find any understanding of the fact that there is also a public interest in people not being subjected to successive complaints?
Well, that, of course, the Court of Appeal. Can we go back
Yeah.
to the judge at first instance, which actually would be the basis? And that's at tab 4. Mr. Justice Owen refers to the in rea solicitor case, which has been referred to on 7 occasions, without your lordship being taken to it, in which Lord Woolf says, and indeed it's cited at paragraph 43 of Mr. Justice Owen's decision, the nature of disciplinary proceedings is capable of mounting such special circumstances. Special circumstances had to be looked for. The facts of the instant case, he said, are clearly to be distinguished, and the conviction complaint was dismissed, whereas in the above-mentioned case, the individual concerned was the subject of both a conduct complaint and a conviction complaint, and was subject to disciplinary action in relation to both. But Lord Woolf's judgment is a powerful demonstration of the public interest in the maintenance of professional standards by disciplinary action, provides strong support for the argument in the instant case the conduct complaint should be permitted to proceed, notwithstanding that in principle it could have been brought at the same time as the conviction complaint. The public interest in allowing to proceed is compelling. So that's one side of the equation. Then the other, moreover, I do not consider the claimant's private interests outweigh that of the public interest. I recognise he suffered from the delay in final resolution of the disciplinary action, delay caused by the failure on the part of the investigating committee, whereas there was no indictable offence in England and Wales corresponding to the offence on which he committed, but he'll now have the opportunity to prove, notwithstanding the findings of the Royal Court of Jersey, he was not guilty of any breach by the Supreme Court, or if he was, or the JFC, or that if he was, it did not discredit himself or the profession. So he has realised that he has been, as it were, troubled by a previous set of
delay isn't
proceedings.
the point, really. It's not so much that there's been delay, as that he's been subjected to these successive complaints.
Yes, but I mean, yes, but there is a reference to the fact that there were previous proceedings.
Yeah.
I mean, that's the point, because there'd been a failure of the investigation committee. And indeed, I mean, it's the fact that there had been previous proceedings was obviously a matter that he had well in account. Can I just see whether, since your lordship raises the point, whether I can find where he knew about, I mean, the factual background is set out between paragraph 8, which is at the foot of page 19, and paragraph 23 at page 23. And in those circumstances, I mean, he was, as it were, well aware of the fact that there had been previous proceedings. and he's merely, in our respective submission, at the passage at which I've referred, recognised that there were these previous proceedings, and that's unfortunate from the perspective of the Mr. Coke-Wallis, but finds it outweighed. I can't take the matter further.
Is it a relevant factor when deciding what weight to give to the public interest in these cases to have regard to the gravity of the offence and indeed perhaps the character of the offender, whether this is somebody who has been convicted or been in trouble before, and in particular whether this is a very grave offence involving perhaps large sums of money, possibly coupled even leading to maybe a custodial sentence on the one hand, and a much lesser offence on the other. Are those factors which are
certainly
relevant?
gravity must be, because if one's asking about the protective stance of the regulator, it's one thing if, for example, one has incompetently blended, let us say, clients' monies with one's own, quite another if one has stolen clients' money, to take a characteristic example. Here, of course, the charge was, in our respective position, a serious one. And indeed, the very nature of the conduct that's alleged, if proven, would in fact excite very grave concern as to what it was that was sought to be being concealed by the removal of these documents to impede and frustrate an investigation that the Jersey financial authorities had considered was required. I mean, my last submission does, in fact, this is, if I may say so, fits well into our 10th submission. Yeah. Yes. Ms. Callaghan reminds me that, having given your lordship the reference to Mr. Justice Owen and only the reference to the judgment of the Court of Appeal, one does find at 25, it's preceding paragraph 26, forgive me, I should have borne this in mind, that in there, Mr. Jones's submission is actually epitomised. Mr. Jones submits the judge gave undue weight to the respondent's interest in maintaining the integrity of the profession and little or no weight to the applicant's interest in the finality of litigation. And then against that, he says at 26, just as there's a strong public interest in finality of litigation, including disciplinary proceedings, so there's a strong public interest in bringing professional disciplinary proceedings in order to maintain professional reputation and integrity both in the profession and as a whole. So that's a more focused, perhaps, than in the somewhat more diffuse analysis of Mr. Justice Owen. But one can hardly believe that, as Mr. Coke-Wallis had the advantage of representing Mr. Jones at these very same points that have been made to you about the problems, and that's indeed exactly why when one goes into autrefoil quittance, one is looking essentially at the question, should one be troubled by second proceedings? So that no doubt Mr. Justice Owen had that well in mind, but like the Court of Appeal, rejected it. So really one has here, we say, that taking the broad merits-based approach and the private and public interests into account, and putting on one side the fact that deference should be paid to the decisions of the lower court and their evaluation, assuming per contra that the Supreme Court will look at it for whatever reason as it were a first instance body, we've stressed the public interest role of the regulator in our printed case at paragraphs 1, 2, 5 and 6. We've stressed the importance in the context of professional men involved in financial services and advice and so on of a conviction of this kind, see paragraphs 129 and 130. We would comment that there's somewhat ironical that it's the appellant who has to rely upon the unacceptability of two sets of proceedings as being somehow pressing him, when it's actually he on whom the obligation would lie to discharge or undermine the findings of the Royal Court and the Jersey Court of Appeal. The other point we'd make is he never appeared before the tribunal on the first or second complaint. He was only represented on the second complaint. He was given every opportunity to do so. I mean, it's the opposite in our respectful submission of harassment, the invitation to and not a denial of due process. And he scrupulously failed to explain to date what actually happened and why he's not even taken the opportunity to defend himself. And we say that a regrettable, and I trust, I can say with some confidence, uncharacteristic error by those presenting the case on behalf of the Institute should not let him, to use the vernacular, loose on the public the points that are made, and very fairly made in Appendix C, that Mr. Coke-Wallis had in some way drawn to their attention the element lacking in the first complaint. All one may say is that there was a needle of a point in what was effectively a haystack of correspondence, which may provide some excuse for those responsible not focusing on the matter. And one notes equally, it is somewhat misleading for Mr. Coke-Wallis if he had a surefire killer point on the first complaint, not to say dismiss the complaint, but rather to say, as he has said at almost every juncture in this long saga, adjourn the complaint, again, which may have not allowed the Institute to focus on the matter. And finally, there were references to some unnamed Queen's Counsel who'd given him an advice which he never actually disclosed. So these were, perhaps I put it more, pleas in mitigation for the Institute in relation to their error. And so that, as it were, they should not bear, as it were, the public should not bear the consequences of that particular error. What we say is, underlying all the doctrines in which your lordships have invited, either in writing or today, or yesterday, submissions, is a balance between the public and private interests. And we ask the question, not merely rhetorically, whether it is really right that the outcome of this should be that if Mr. Coke-Wallis indeed committed the offence of which the Jersey Royal Court found him guilty, he should nonetheless, because of what has transpired, be free, which would be the consequence to practice as an accountant. Now, the oddity of these particular proceedings is this, because at the time when the Institute determined that, having rejected the arguments on abuse of process and the like, the second complaint should be heard, Mr. Coke-Wallis had been refused permission to appeal by the Court of Appeal, had applied for permission to the Supreme Court but 3 months out of time. A view was taken that that was inadequate basis for yet further adjourning of this particular matter. In the event, what happened is that the conduct complaint was heard. Now, we have, for our part, accepted that if your lordships determine this appeal in our favour, in the favour of the appellant, the decision of that tribunal will have to be treated as a nullity on the basis it should never have occurred at all. But it is worthwhile, before leaving this matter, to say that one doesn't actually need, in the circumstance, to speculate about what the tribunal might consider, both in terms of fact and of law, in this particular area. Can I just ask you to go very briefly to the determination, which you have at tab 17 on Appendix 2. And one sees what happens there. There were 2 complaints, one of which your lordships are entirely unconcerned with, but the main complaint is the conduct, the breach, when aware of the Jersey direction. Without wearying your lordships with the pre-history, one can see that yet again Mr. Coke-Wallis declines to attend the hearing, and yet again, which is a characteristic tactic, he asked at the very last moment for an adjournment on a number of grounds that the tribunal found unsatisfactory. Then, if you go to page 443, that's page 7, you will see that in the absence, of course, of any contradictory evidence at all, the tribunal accepted, as they were bound to accept, were likely to accept, but certainly were not acting with any impropriety in accepting, the evidence contained in the witness statements of Helen Hatton, Nicholas Troy, Peter Beamish, and Christopher Cook, on which, of course, no cross-examination was going to be directed. And they noted that the defendant's narrative account, he accepts he removed documents and records, was attempting to take them out of Jersey. They then, at 11, 12, 13, find that the direction was made. At 14, they found that the removal was thought to be effective. At 15 and 16, they find that it was served on Mr. Coke-Wallis's wife, but not on him. Then they address themselves entirely correctly on the basis that they need to find that Mr. Coke-Wallis knew about the direction, and they say that for various reasons in 18 they find on the balance of probabilities that he did know that. They refer to the way in which the documents were concealed in the car, the fact that there's no challenge to the documentary evidence, the declining of Mr. Coke-Wallis to answer police questions in the interview. They refer, as they were entitled to do in a 7-1 case, to the findings of the Royal Court articulated by the Commissioner in sentencing. They found it was prima facie evidence, and then they went to the Court of Appeal of Jersey, and then they made the findings of fact in 20 on the balance of probabilities. The facts alleged were proved that those facts, second part of the equation, he had committed an act likely to bring discredit on himself, the Institute of Professional Accountancy. You may ignore complaint 2. You may note, since Sir John Dyson did ask as the relevance of this, there was no previous disciplinary record. In fairness, I should draw that to your attention. And then their conclusions on complaint 1. 31, they set out 2 essential requirements of a member. The good name of the profession, high standards required. Hard to think, they say, of a more serious example of a chartered accountant being in flagrant disregard of a regulatory authority. They note what they consider to be aggravating features: professional capacity, actions pre-planned, deliberate concealment of evidence, attempt to avoid audit by the regulator, total lack of integrity, constitute gross misprofessional conduct. 33, failure to cooperate with the police and Jersey court, or indeed with the institute, and they therefore determined that the complaint exclusion was the only appropriate and proportionate sanction necessary to uphold the good name of the profession, maintain public trust in the profession, and demonstrate that such conduct cannot be tolerated. They don't fine him because he had to pay costs. They do note that he has the opportunity to apply to be readmitted to membership. This may be one of my Lord Clerk's points, though they recommend that no application be even entertained for a period of 5 years due to the serious nature of misconduct. But of course, it will be determined whenever it is on its merits. And then at 38, of course, no doubt reflecting what your Lordship may feel is an imperfect still understanding. They wish to make it absolutely clear the defendant's conviction was not taken into account at all in deciding upon the appropriate sanction. So if your Lordship were to say, well, they went a very long way round, something they could have gone a short way. Well, actually, in that case, they could not have, because of the missing element. So, but they wanted to make clear well, and forgive me, of course, they couldn't take into account under 7.1. They could have taken into account under 7.3. Well, they say they couldn't because it wasn't the conviction but the findings. And
well, they did take it into account. They took account. They applied Section 7.3b, didn't they?
Yes, I think the answer is that they again are distinguishing between what the conviction establishes and what facts found by a convicting court established. So that your Lordships, as I say, need not speculate. Your Lordships are faced, in our respectful commission, with a choice. Is the consequence of a strict application of the law relating to res judicata, or even the more flexible application of law relating to abuse of process.
If we're to test this matter as at the date of the commencement of the allegedly abusive proceedings,
Yes.
are we entitled to take into account these subsequent events?
Well, I would have said, my lord, well, let me put it this way, it's not uninteresting to note.
Well, I can see from your point of view it's very interesting, but the question, my question is whether, if we have to test whether there was an abuse as at the moment of the beginning of the allegedly abusive proceedings,
yes,
namely whenever it was, is it right in principle to take account of what happened subsequently?
Yeah, well, my submission would be yes, and the reason would be that on the way in which the doctrine of abuse is now formulated, pursuant to Johnson and Gorwood and Goldberg, Lind and the like, one has to look forward, first of all, so what would be likely to happen. Secondly, it's a general principle of law that when one actually knows facts, one needn't speculate. Here one knows facts. I mean, otherwise I would simply be saying look forward to the possibility that the tribunal, in considering these matters, given all the history of it, are likely to inculpate him and likely to see what was said by the first tribunal obiter, see what was said by the president in the Court of Appeal, very likely to find, as a reasonable body, that this was bound to be discreditable conduct of a serious nature, instead of which I could say, well, actually they did.
Strength of the case.
Even if I can't look at what did happen, I would still be arguing that that's what would be likely to happen. And that's where the public interest is involved. After all, one could always have said, it has always been open to Mr. Coke-Wallis to come and say the Jersey court were wrong, and they were wrong for the following reasons. He's never said that, and I wonder what inference your lordships may wish to draw of that signal absence of taking the opportunity afforded to him on so many occasions now, 4 occasions, well, 3 occasions, because the Jersey Court of Appeal would not have reheard him, 3 occasions, actually to provide an acceptable explanation for this serious offence. And also, unless I can assist your lordships further, those are my submissions on behalf of the respondent.
Thank you. Ms. Callaghan.
My Lords, I'm grateful for the opportunity, but I have nothing further to add to Mr. Beloff's submissions.
Thank you. Yes, Mr. Curl, you're going to reply, are you?
My Lords, I'm going to reply on the issues that I dealt with in opening submissions, and Mr. Jones will deal with abuse. With your Lordship's permission, of course.
Yes.
Before turning to the points about cause of action estoppel, however, I would just like to correct one inadvertent factual inaccuracy in my learned friend Mr. Beloff's submissions. The appeal to the Supreme Court was not lodged 3 months out of time. There were transitional arrangements as between the House of Lords and the Supreme Court. On the 12th of August 2009, well within time, my instructing solicitor, who is in court, was told by the Supreme Court that time was extended to the 30th of September.
Right, yes.
That is the position. So the appeal was not out of time. The conduct complaint went ahead, even though the matter had not been disposed of by the Supreme Court. And it is for that reason that Mr. Coke-Wallis didn't engage with those proceedings, because he preferred to hear what your lordships had to say rather than what this tribunal had to say. And in my respectful submission to your lordships, that was a perfectly reasonable thing for Mr. Coke-Wallis to do.
If risky.
Indeed, my lord. Turning to the substance of Mr. Beloff's submissions, in my submission, the point at point 6 only works if one accepts the Institute's construction of the bylaws. And to that extent, turning to point 5, I have nothing to add or amplify to my earlier submissions on act or default. Conviction can't be an act or default. The points have been very well ventilated by your lordships, if I may say so, and I really can't better what I said yesterday. Turning to point 7, this point, that there should be a public interest exception to res judicata, is a new point. It's not in the Institute's printed case. It's brand new. I'm responding to it now, today, on my feet. I've not had a chance to consider this previously. I would ask your lordships to give some weight to the fact that this appeal has been on foot for a year. Our reasons were in our petition. The Institute hasn't raised it before this morning. Also, not only that, I would invite your lordships to turn to paragraph 116 of the Institute's printed case at tab 5 of the core volume. And there it says, cause of action estoppel operates as an absolute bar to relitigation between the same parties. That is the Institute's case up until this morning. The Institute now says that a public interest exception should be invented to res judicata. And it would be inventing such an exception. It would be unprecedented and unique anywhere in the common law world where res judicata is accepted as an absolute bar. And there's an air of desperation about the fact that the Institute has thought up this argument this morning.
Is there any authority for the view that res judicata applies in its technical sense to disciplinary proceedings?
My Lord, there is no authority to that effect, to the best of my knowledge. However, to invent an exception, I repeat, would be totally novel. And the real public interest to which I would urge your lordships to have in the forefront of your lordships' minds is that the public interest in res judicata is already there. The public interest is in the finality of litigation. It is an absolute bar. And if we start synthesising, if your lordships begin to synthesise exceptions to res judicata, then where does it stop? And of course the point has been very well made that in criminal proceedings, where the public interest is absolutely of the highest, there is no exception, and it is right that there is no exception. Cause of action estoppel, my lords, is an absolute bar.
No exception except the statutory one that's now available where there's fresh evidence that wasn't available.
Well, indeed, my lord. And I would invite your lordships to... There's also the exception in the section 29 that my learned friends have produced for health care workers, and that simply shows that where the legislature intends for there to be an exception, it so provides, and the exceptions, the very limited exceptions to autrefois that are now provided for in statute show that where these matters are to be disapplied, it's made absolutely clear by the legislature. I just simply reiterate, my lords, that cause of action estoppel...
Is there a criminal case in which this point has been discussed?
My
Or
lord,
has it always been treated as axiomatic? That autrefois acquit or autrefois convict is the end of it?
My lords, to the best of my knowledge, it is so axiomatic. I'm unable to assist further with authority. Cause of action estoppel, my lords, is an absolute bar, and unless there is anything further with which I may assist your lordships, those are my submissions on that point.
Thank you.
Most grateful.
Yes.
My lord, the only point I seek to make in reply is in respect of the suggestion by my learned friend that when one considers all of the circumstances, the prime reason for doing so is to decide whether one should proceed with the second case or not. Whereas that might be the effect of the decision or of the consideration of all of the facts and all of the interests. And whether my suggestion that one should apply retrospective analysis rather than a prospective analysis is purely on this point and this point only. The whole purpose for considering the broad-based merits is to consider whether the first action should have included that which is to be included within the second. That was the purpose of the consideration, nothing more and nothing less. And that is exactly, and if I can go to this authority and this last authority alone, and I ask forgiveness because I have looked at it once before, but I would like to look at it once again so I can make my point with full clarity. And that again is the case of Stuart Goldberg. It's in volume 6. It's found at page 840. And this, in my respectful submission, demonstrates that the slant that my learned friend seeks to put on the purpose of the consideration is a wrong one. It might assist him, but it's a wrong one. What it is, looking at the top of the page of page 840, in my judgment, when Lord Bingham spoke of a broad merits-based approach, the merits he had in mind were not the substantive merits or otherwise of the actual claim, but those relevant to the question whether the claimant could or should have brought his claim as part of the earlier proceedings. That is the prime purpose of the exercise. That is the consideration of the exercise. And it's at that stage when all of the points that my learned friend brings to play, the heavy responsibility, the great duty, the obligations that the Institute have by reason of the public interest, it's those considerations that are brought into consideration to decide whether they should have brought it in the first place. My Lord, of course, our prime case is that, or our case is that the first and second complaints were the same, and accordingly is covered by cause of action, estoppel, res judicata. It's only when we move into the realm of abuse of process, then we look back. We ask that question, should they have brought it in the first place? My Lords, all of the circumstances, all of the evidence, all of the indications give a resounding yes. My Lord, there was then criticism made, and I, with the greatest respect to my learned friend, he's taken the wrong point that I was seeking to make in Wharton and Gardner. It was not that public interest should not come into play, far from it. But when one considers the seriousness, if not the outrageous facts that underline that case, if there was ever a case where public interest should dictate that the matter should have gone forward, it was that case. But it was considered, on balance, that the facts of the second complaint were so similar to the first that, notwithstanding the massive public interest, and there was a great outcry, the answer was no, you do not proceed. That was the point of my reference to that case, and not as my learned friend would have this court believe. My Lords, unless I can assist further, they are our submissions. I think everything that is set out in our written case covers all of the points that are raised against us. And accordingly, my Lord, I would ask that this appeal be allowed.
Thank you. The court is grateful to counsel for their submissions and will reserve its judgment.